the poor person, the police inspector found that the possession of these three precious things were not found suspected. So he released the person from the confinement. Now the poor person filed a complaint again in a police station for wrongful restraint for the period for what he was confined. When this case came before the High Court of Bombay, the court examined the fact and came to the conclusion that the constable put the person behind the bar wrongfully, that is admissible, that is proved. But the constable acted in good faith, and the benefit of mistake of fact was granted to the constable by saying that the constable examined the poor person. After examination, he put the person behind the bar. The time was so, the appearance of the person was so, and the property found from the person was so that any person can put under the impression that there is something wrong with this combination of facts. And he acted in good faith because he took due care and attention. How one can prove? He investigated, he examined the poor person by asking questions. So he acted in good faith. It is only the mistake of fact that was responsible for that confinement. So he was granted the benefit on the principle of mistake of fact is excusable. In another case whereby mistake of fact was not granted as the exception. Dear friend, it is under the case of Shio Sharan Sahai versus Muhammad Faisal Khan. In this case, the person who lost his horse just before a week saw the resembled horse who was present in the premises of B. As he saw the resembled kind of horse standing in the premises of B, without inquiring B, he was considered this horse as of him. And without investigating or without inquiring, he believed that either B has stolen that horse from him or he has purchased this stolen horse from someone. And as this person was the police officer, as when he joined his office for that day, he called upon B and inquired from B that from where this horse was there. So B explained that he purchased this horse from S. This police inspector not inquired this person S, and as soon as he came to know that B has purchased this horse from S, he called S and put him behind the bar, as well as he rejected the bail on the ground that he is the person involved in selling and purchasing of stolen things. That after this particular incident, the person S charged policeman by this particular offense of wrongful confinement, whereby court examined that the police inspector was not acted in good faith. He acted with some prejudice and he examined B, but he did not ask any question to S. He did not acted with due care and attention. So here, though there was a mistake of fact that S was not a person who was involved in selling and purchasing of stolen property. So mistake of fact was there, but the person was not acted with good faith, so the exemption was not granted to the police inspector, and it was considered as the bad defense of mistake of fact. So dear friend, mistake of fact is cleared. Let us shift to the another point of mistake of law. Dear friend, the principle ignorantia juris non excusat, which means ignorance of law is not an excuse. This is the second ingredient for section 76. Law presumes that as soon as a person put his first leg or first foot on the land, he is bound by each and every law which is prevailing on that land. So person is bound by each and every law, whether he is aware or not aware by that law. It is also accepted by common law that whether the law is published or advertised by the government, by the state, person is bound by that law as soon as he presents on that particular land. So we Indian, whether we are knowing the provision of IPC or existence of IPC, we all are bound by the provision of IPC. Not even IPC, by any law which is in existence in India. This is the principle which is shown in this principle of mistake of law. If a person commits any mistake on the basis of law, he will not be granted any kind of exception, because person is bound by law. It is written in section 76. Person will not be granted any kind of exception if he has committed any mistake of law. If that mistake is committed, the exception starts if that mistake is committed with good faith and under the belief that person is bound by law. A policeman, by following the order of his superior, firing on a mob, then person is not responsible for the consequences, because he was acting under the order of his superior, that he has to follow each and every order passed by his superior. He has been told to fire on a mob. Whether the person present in that group is responsible for any crime or not, that is not been examined by this particular constable or police officer. He has to simply follow the order. So whether that order is legal or not, that is not the duty of a police officer to examine. So if any mistake is occurred from the part of the superior, police constable is not responsible for that mistake, because he acted as per the order. It is called the exception. The person is not responsible for mistake of fact if he has acted with good faith and he has acted under the impression that he is bound by law. Dear friend, mistake of law is also not available for any newly passed order, which means if Parliament has passed any new act, a very recent act which was passed just yesterday, and person has committed an offence today, the order or the law passed yesterday, as soon as it is made applicable, immediate application is declared, all are bound by that newly passed law, whether person is aware of that law or not. Person is bound by newly enacted law also. If any mistake is committed relating to that law, person is not having any exception if he has not acted in good faith and he is not bound by law. So this is the second ingredient of mistake of law. The next ingredient we have discussed simultaneously while we were discussing mistake of fact and mistake of law as the good faith. As good faith is defined under section 52 as nothing is said to be done or believed in good faith which is done or believed without due care and attention. I am repeating the section as I have discussed it simultaneously with first two ingredients. Nothing is said to be done or believed in good faith which is done or believed without due care and attention. The next is nothing is an offense which is done by any person who is justified by law or who by reason of a mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. Dear friend, as mistake covers section 76 and 79, both discuss about mistake of fact and mistake of law. But both the sections are different by way of person who is committing this mistake of fact or mistake of law. Under section 76, the person who is committing this mistake of fact is bound by law, whereas section 79 says that person believes himself, as you can see in slide, to be justified by law. The point of difference is words of 76 are to be bound by law and words of 79 are justified by law, which means under section 76 person is bound, which means person is acting either as per the order of a state or acting as a state. It is his legal duty which has forced him to act in that manner, whereas under section 79 person is not legally bound by doing that thing. He is believed under justification of law, which means it is his moral duty to perform that task. He is not legally bound to perform that action. It is his only moral duty. So this is the big difference between section 76 and 79. Section 76 is applicable to public servants or the person who has performed his legal duty. Section 79 is applicable to a person who is under the belief of justified by law, acted in that manner. So section 79 also discussed about mistake of fact is permissible but mistake of law is not excusable. So this is the first part of general exception. Let us discuss the next section, section 80, which says that nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge, in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. Dear friend, this particular section is also known as an accident. Accident means sudden happening of any incident, where the happening of such an event is not in the hand of a man. Something suddenly happens, then that particular incident is known as accident. Accident is not defined under IPC, but it is covered by this manner that anything which is done by way of accident, not with criminal intention. Criminal intention means not with any kind of bad intention, or any kind of manslaughter is not involved, or by doing any lawful task in a lawful manner, or by any lawful means, lawful measures, person is acted fully in with the context of law, and suddenly some accident taken place, then he is relieved from the punishment for the consequences. A, who is the sailman of a boat, suddenly saw that a huge boat is coming opposite to it. To avoid this big accident, if he collapsed with a smaller boat, then it is called the person has acted to avoid big accident, he committed small accident. I can give you another example of this accident. See, sometimes accident is also considered as necessity, which is necessary to avoid the big harm. If person commits small harm, it is excusable. Accident as happening of this event is not in the hand of a person. He is excusable out of the consequences, and he is excusable from the punishment. The ingredient for this section is absence of criminal intention,